Carolyn Rye, Chair of the School Board of the City of Virginia Beach, Virginia, and I hereby call this special meeting to order at 5:01 p.m. on this first day of February 2022. In accordance with the schedule of school board meetings amended and approved by the school board at their January 25th, 2021 regular meeting, and pursuant to Bylaw 146 and Virginia Code 22.3-07, the school board will hold a special meeting on Tuesday, February 1, 2022, at 5:00 p.m. in the school board chambers of the School Administration Building Number 6 at the Municipal Center, 2512 George Mason Drive, Virginia Beach, Virginia 23456. The purpose of this special meeting is for discussion and possible action on the new election districts and election cycles for the school board. Pursuant to the school board's 21-22 reopening plan adopted August 10th, 2021, and the school board vote on August 24th, 2021 regarding health protocols for school board meetings, physical distancing will be used in chambers as a health mitigation strategy. And as always, members of the public will be able to observe this special board meeting through live streaming on vbschools.com, broadcast on VBTV channel 47, and on Zoom. With that, Madam Clerk, would you please take the verbal roll?
Thank you, Madam Chair. Present in school board chambers is Chairwoman Rye, Ms. Melnick, Ms. Anderson, Ms. Felton, Ms. Franklin, Ms. Holtz, Ms. Hughes, Ms. Manning, Ms. Owens, Ms. Riggs, and Ms. Weems.
All right, our agenda was previously adopted, so we are now with agenda item 4, open session discussion regarding new election districts and election cycles, and we welcome School Board Counsel Mrs. Linetti.
Good evenings, Madam Chair, Vice Chair, school board members, and Dr. Spence. I'm Cami Linetti, School Board Legal Counsel. What I'm going to present to you tonight is a PowerPoint to help start the conversation to just show everybody where we are. So, Mrs. Toniana, can we pull that up? So, see if I can drive this. Okay. Just want to clarify how we are in the situation where we have new election districts for you. There was a case filed, Holloway versus the City of Virginia Beach, on March 31st, 2021. The federal court, Judge Jackson, ruled that the city election system violated Section 2 of the 1965 Voting Rights Act case. So that decision came out last March. When the decision came out, the judge then ordered the parties involved to come back with draft proposed election systems for the city. That was originally due back on July 1st. That took a little while to do. There were a number of public hearings about that, and when the parties could not reach agreement on it, they submitted different plans that eventually came into the federal court. Because there was a difference between what the city was proposing and the plaintiffs in the case were proposing, the court appointed a special master. The special master's job was to review the plans submitted by both parties and come up with a recommendation for the court. That special master's report was submitted on October 26, 2021, and there was a minor change that came out on December 23, 2021. On the October 26, 2021 recommendations, where when we started looking a little bit stronger at the school board, what we're going to do, the election districts and the cycles that we're going to apply to you at that time period. We were waiting for the judge, and we've had some discussions about this, we were waiting for the judge to finalize the order. That order was finalized on December 22nd, and he adopted the special master's plan as fixed. So it was a minor change in one of the proposed districts, and that came out. So Judge Jackson issued his final order, and he told the city that they now had to implement the new election districts. The city is referring to this as the remedial plan that the court ordered. So that's how if you hear the city referring to it, that's what they call the remedial plan, is what we're working under right now. The city council has since appealed the decision to the Fourth Circuit Court of Appeals. While that matter is pending in the Fourth Circuit, they are going forward and implementing the remedial districts as planned. So they're going forward as a court order, but they still are going to challenge this with the Fourth Circuit. It's my understanding that I believe will be March, or there will be oral arguments in the Fourth Circuit. We don't know when the final decision will come out after that. And again, what the court ordered under the decision that Judge Jackson ruled, that the city would have a one at-large mayor position. There would be 10 city council positions. 3 of those positions are what are referred to as majority minority opportunity districts, where there is a large amount of minorities than Caucasians in that districts. Those districts are 4, 7, and 10 that are listed as the minority opportunity districts. They also, at the time, because the Constitution of Virginia requires localities every 10 years to look at the census data and redistrict, they were able to take the new census data from 2020 and redistrict with that, so they combined all that together at one time. So again, they probably would have had to redo some of these districts anyway. As a result, the districts now have approximately 46,000 residents in them and approximately 36,000 voting age population in each one of the districts. They're not perfect, but they're closely aligned. If you want to know more information about this, the city website has all this information on it. There it has, if you press pop up, it comes right up on the front website. Let's see if I get a picture. Oops, sorry. Real quick, before I go to this one, these are the districts. This is one plan on there. This is all available on the city's website. These are what the full plan would look like. And if you were to go to the city's website, this is what you would see. There are several pages on there that explain this. On there, you could go into the election system. It will go through this. There was a presentation on January 11th, 2021 for the public, 2022 for the public. It's about 15 minutes long. You can click on it. It very clearly explains exactly where we are in the status, what the city is planning to do, and the understanding on the election system. During that presentation for the city attorney's office to the city council, and again, it was public, they mentioned that they believe that the school board is required to follow the same election districts that the city is. They're anticipating that it's going to be there by inference. And as I meant, we can talk about tonight what we mean by inference. Additionally, during that presentation, the voter registrar, Donna Patterson, got up and spoke, and she explained where the registrar's office is, that they allowed petitions to be going out for the local elections and the General Assembly elections on January 3rd. And she will accept them in, but she will not process them until she's been given final authority as to what elections are going to go forward, knowing that there's a court case, also knowing some of these things now have to clear for the Virginia Voting Rights Act through the Virginia Attorney General's office. Again, as I mentioned, you can go to the links I'll put on there, but you can also go right to the City of Virginia Beach's website. The whole presentation's there. All the documents from the federal court case are loaded up there. The maps are up there. If you are looking to see where your district is, you just plug in your address. It can also take you right through all that. Everything is available to the public. This is not the first time the city has presented on this. They've had several public hearings. If you remember, Mr. Boynton came to you last year and presented the same presentation they gave to City Council where they were at that time. This was an updated presentation. But again, all this information is public. Just for clarity purposes, the election cycles and districts for the city council members listed, and the way I listed them is by the way the elections will come up. In the 2022 elections, districts 2, 4, 6, 8, 9, and 10 are due for election. In the special master's report, he mentioned that the reason he chose these was because these were those city council members whose terms ran up in 2022. So again, for the city council, District 2, you can see who's listed there, the current city council members that would be in those seats. There are 5 elections set for the 2024 election. Again, the reason the special master chose that is because those are the persons on city council who would have their terms expiring in 2024. District 1 is the only slightly confusing one. It is would normally be a 2024 district, but Mr. Holcomb was in that position temporarily. He needs to run again in a special election, so it will be a special election in 2022, but he's finishing the remainder of the 2024 term. Otherwise, all those districts are set to run up on 2024. This is what it looks like for the school board. And this is where our situation is a little bit different than what City Council has. Currently for 2022, District 2, you have Mrs. Melnick. She's got a term that ends in 2022. You have Mrs. Riggs, who has a term that ends in 2024. We have no currently elected school board members who live in the new District 4. District 6 has Mrs. Felton, who has a 2022 term, and Mrs. Anderson, who has a 2024 term. District 8 has Mrs. Rye with a 2022 term. District 9 is where it gets complicated because you have 4 members there. Mrs. Weems, Mrs. Holtz, and Mrs. Hughes all have 2022 terms. Mrs. Manning has a 2024 term. District 10 does not currently have any elected school board member residing in that district. 2024, District 1, Mrs. Franklin, 2024 term. District 3, Mrs. Owens in a 2024 term. And then we don't currently have anyone in District 5 or District 7. We're referring to this as the at-large position, while Mrs. Mandy and Mrs. Anderson are at large. We don't currently have anybody formally elected equivalent to what the mayor has because our system is slightly different. So our situations become, how do we interpret, what do we do with those members who live in districts in which there's an election in 2022? So going back, looking at what some of the law talks about in this area, the Constitution of Virginia, Article 7, Section 5, talks about what the role of cities, counties, and local governing bodies have to be. They have to set the number and the boundaries of election districts, and they must reapportion every 10 years. So as I mentioned before, that's why we did the 2022 census data into that. Code of Virginia 24.2, 304.1 also states that the governing body has to provide for election board members. It listed 3 ways you could do that, which involved at-large, a combination at-large, or by districts. Some of that has now changed with the Virginia Voting Rights Act that went into effect in 2021. We have a limitation on what you can do with at-large, so that does affect where we are. Code of Virginia 24.2-304.6, city and school board members get to complete their terms regardless of the residency. This particular provision has to do with when you have redistricting situations. You remember, we've had that in 2010. We actually had that situation with one of our school board members who was allowed to remain on. We think that that would be the equivalent statute you would look at as to those of you who are in carryover terms, that your term cannot be limited by the population. You would have to finish out your term, or you could vacate the position, but otherwise you get to keep your term until 2024. Code of Virginia 24.2, 311B, members of governing bodies, when decennial redistricting happens, shall complete their term. That's another statute that talks about why you have the right to complete your term when your district changes. Other laws that specifically pertain to school board elections, Code of Virginia 24.2, elected school boards serve the same terms as their governing bodies. Code of Virginia 22.1, 57.3, this is a very complicated statute. We've been through this before. Section A says school board elections coincide with their city council elections. B, school board has the same number of members as city council. And C, and these are just summaries, there's more complicated language to this, but C is school board member elected for the same term at the same time as their corresponding city council member. So if you're District 2 for school board, you're District 2 for city council. Also on the Charter of the City of Virginia Beach, Section 16.04, all school board members elected in the same manner and according to the same schedule that city council members are elected for terms of 4 years. Now, I will note that there are 2 subsections to 16.04. Section A is this section that mentions this. Section B also says it will be at large. We believe that that is now no longer valid because the city is not being allowed to use the at-large system, but that's also a complication. The Charter of the City of Virginia Beach does need to be changed when we have resolved this particular case. They will do that once they've got a final resolution on it. Charter changes are something the city must initiate with the General Assembly. It is a complicated process involving public hearings. It usually takes 2 years to get through the General Assembly, so that is not something we anticipate would happen right away. Candidates for City Council School Board. We believe that the city is presuming that the school board will follow the same election cycles that was at least mentioned in its January 11th presentation for the public at that point, although we all understand that there is some ambiguity right now in the law. We also know that the Register of Voters had said that on January 3rd, 2022, the petitions were made available for city council and school board, so the Register is assuming that those school board members who have terms that are up in 2022 will be having elections in November. The Register said she will accept but will not process petitions until she's further authorized. As I mentioned, we've got court cases and other things that are happening, but she will, when authorized, she'll go ahead and process that. June 21st is a primary deadline for non-primary and independent candidates, and September 23rd is when early voting begins, and again, you have the November 8th election. So you can see why there are some time crunches that we need to deal with. Sorry, I'm not at that. So that is putting you where the law is at this point. As we mentioned, we've met about this before. It is our position that the school board doesn't really have authority to determine what the election districts are, but you do have to interpret what has happened at this point and how does it apply to you. And we believe that our assessment right now is that you are required to follow the same procedures, same election cycles, the same districts as the city council has. They will notice for you that there may be some wording change eventually when we get into the system fully implemented. We call them right now districts because a district can involve everybody in the city voting for somebody in a district. If it's only going to be the people who live in a district, an actual ward, voting for the people, you tend to change the name to wards. So you'll see that in the city of Virginia Beach has wards. So probably when the final system comes out, we'll be referring to what we're now calling districts. Will probably eventually become wards at that point. That's a different law change that's coming out there. But at the moment, we're going to call them districts until that's clarified. So that, I think, is a brief summary as to where we are on the law and what we think the situation is.
Thank you. Mrs. Riggs?
I just wanted to ask why you're talking about the districts, wards, whatever are they still, I know they're districts by the numbers, but are they still going to be referred to with a name like Centerville, the beach?
I've not
Princess
I've
Anne?
not seen any names attached to them yet. And so I'm not sure, I'm guessing that the city would have responsibility for setting the names as to the districts, and the city will do that when they determine the system is finished, but I've not heard them actually referred to as a specific name. Right now, I just hear them by the numbers or the at-large mayor position.
Okay, thanks.
And Mrs. Linetti, could you just add a few words of, so you've brought us up to where we are now and what still needs to be done in terms of our body?
The concern that some have had is how to resolve the situation where you have school board members. We have some positions some districts that currently do not have a sitting school board member in them, and some where you have multiple school board members in them. We firmly believe that those of you who have 2024 terms, you remain on the board. I am not sure it would be accurate to say that if you live in District 2, and I'll use Mrs. Melnick as an example, and Mrs. Riggs also lives there. Mrs. Riggs is a 2024 term. I'm not sure it's accurate to say that you've been elected to represent District 2 until you go through the election. And I've heard some people say re-election. This will actually be, these districts have just come into effect when the judge put the order out on the 22nd of December. So their first elections will be in 2022. So you will be elected to that district in 2022. In the meantime, you are the district from, I guess, Centerville, being Mrs. Riggs. I'm not sure, Mrs. Melnick, what you call it, your district, but that you remain that person. You get to remain on the school board in such time as you either get off or you run for a different election.
Got it. Ms. Manning.
But again, as far as what next steps for this
Okay,
board would be, I mean, generically speaking, and one.
The question was, who had responsibility for resolving the issue at the school board? And we looked at this, and we don't believe that you have any authority to set the election districts or the cycles. You can obviously talk to your counterparts on city council. The city council could determine when the election or the staggering of the districts are, should that come out there. But the question is, no one has stepped forward to say, how do you resolve this if people are unclear as to what should happen on it? So one of the things we did, and the school board did, was talk with some of our representatives to see if we could get a bill in the General Assembly. Could you just clarify language in a situation like this? Not necessarily relevant to Virginia Beach, but when you have a court order and it affects the system, what are we supposed to do and how do we interpret it? And that was a bill we've been working through some language on, and it did eventually become House Bill 1031, and it's still out there. It has not come up to committee yet. We expect it to come to committee in the next week or so because crossover is on February 15th. So it needs to come up fairly quickly, and the question is that the language we want? We've had questions that other people have proposed amendments to that and changes to that. So the question is, who's speaking on behalf of this bill, and how are we going to get the language out there? And what would happen if it's not clarified? That's the other issue. What do we do if this is not clarified and something happens? How do we respond to it? That is an issue we've been looking at for several months for you. So right now, the issue that we're looking at is we have a bill pending in the General Assembly, again, HB 1031. If that goes through, it should probably resolve our issue, but if it doesn't go through or it gets amended, how do we respond to that and what actions do you want to take to that? So that question's come to the board is what do you want to do at this point? There have been some questions in the last week as to changing the language or who's speaking on behalf of the city of Virginia Beach, and we've been trying to resolve that for you with your legislative consultants.
And this is to address a gap in the law, was one phrase used. This judge order that doesn't speak to the school board, this body that was not a party to the suit.
The school board was
and-
not
and-
made a
and
party
it's
to the
not
hallway suit.
addressed in the order. So this is the gap we're attempting to resolve right now, so that there's some authority that certifies for the state board elections ultimately, who would, how to call the election for the school board.
The draft language we put in is generic, that it would help anyone that runs into the situation
Oh,
in the future,
wasn't
yes.
speaking to that, but
Yes.
again, just to recap, and this is one part of that process, but again, so that we landed here with your presentation, and what remains is still a governing authority to certify what the school board elections would look like. And we know what all this legislation and these state codes and city charters say, but still one avenue is for the General Assembly to pass legislation that presumably the State Board of Elections would weigh when they give their direction to the local board. Is that a fair summary of
I believe that would fairly represent one way to do this. The other choice would be, and I do not see a way that the school board would be able to have standing to go into court to ask it to be resolved, but somebody would be looking to see what does the law say on this, and you as a body who has some interest in knowing what the gap is, because it will directly affect this board at some point in the future if we don't get this resolved, have proposed legislation. So that is one method to do that, that we think getting legislation will help those bodies who have to resolve these issues clarify what needs to be done. If that does not go through, then we may have to look at other options. Somebody would have to look at other options as how do we resolve this.
okay. All right, colleagues,
Oh,
With
yeah,
that-
Mrs. Manning is next.
Mrs. Manning.
Okay, I have a few questions. So I've heard you say a few times, the school board does not have any authority over how the November elections are conducted, correct? That's a Department of Elections decision. Is that accurate? We don't have authority over that?
Correct. You do not, the authority is granted to the local governing body, and then setting elections can be
So
either.
City Council and the Department of Elections.
Correct.
So the school board has no authority over how the elections are conducted, correct? I've heard you say that a few times, just wanted to verify.
Correct.
Okay. So we're elected individually, not as a collective board. We can't come in here, bring our campaign signs with us. We can't talk about it during our meetings. We never have, we never do. We run as individuals. We don't talk about endorsing any specific candidate. So I'm wondering, under what authority do we have to advocate for or against anything related to how it's going to impact us individually as board members? I understand that we have to make sure that we have a body in place, but under what authority can this board advocate for or against any particular viewpoint on how we're individually elected?
You are not advocating for that. What you're asking the court is to clarify law where there appear to be ambiguities or gaps in the law, which is what the General Assembly does, is pass law. So we recognize that there are gaps in the law and what to do in these circumstances. And so you have asked for legislation that will clarify, and this isn't written specific to Virginia Beach, it's a generic wording, that anybody else finding themselves in a situation where a court has ordered something, this is how you proceed. There is law that talks about what happens when you redistrict and it changes your election system, but there is a gap as to what happens when there is a court order and how you interpret that. So that's what you're advocating for, is a law that clarifies it. How it affects anybody individually really isn't the issue here. The issue is how to resolve this law, what is an appropriate interpretation. It does appear that the General Assembly would be the right body to clarify a law.
But we don't have any authority over any of this. It's City Council and the Department of Elections. So why isn't City Council and the Department of Elections the ones advocating to make sure that we have the proper election system in place? Why is it us?
I cannot answer that, but it seems to be you're the only body that's taking an interest in this at the moment.
I don't see, we're only supposed to, we only have the power given to us through law, and I don't know where in the law we have the authority to advocate for something that's going to impact us as individual elected members and individual elected members, candidates of the public, because these aren't our seats. These belong to the public, not to us individually. So that's where I'm just a little confused as to,
I would put in
why
the
we're even
category if
having
you
these
change from like a
conversations.
November election to a May election, that would also might possibly affect your ability. But this bill is not saying Virginia Beach, we don't want somebody to run. This bill is saying when a court order does it, this is when a court order affects this is how everybody should interpret it.
Okay, so my next question is, if you could go back to the city council, the slide where it showed all the different districts and who's in those. Yeah, right there. So it shows basically, city council has a person, an incumbent, in all the seats for 2024, right? So they have somebody slated to be
They
in.
have, I wouldn't say, nobody has, your election districts are brand new, so nobody has been elected to their districts yet. The ones on the right column, the 2024, the opportunity for the citizens of Virginia Beach to elect people to these districts will be in 2024.
Okay, let me ask you a question. If District 5, that's slated in 24, let's say in June of this year, the person in District 5 decides they are gonna quit their job, they're removed, something, that's an empty spot. What would then be done in that situation with city council there if there was an empty spot in District 5 for 2020?
If I'm correct in this, and again, I would want to consult the city attorney's office further, but what I believe what you want to do in these circumstances is that you need somebody to fill the remainder of this time Mrs. Wilson's term. So you get to elect somebody, and there's actually equivalent law that talks about in a redistricting situation, if you change and somebody leaves, then you would, it's weird, but the law actually says, as best as possible, as you can approximate the prior district that person was elected from, those people would elect them from. Now, in Virginia Beach, it's not that hard because everybody elected everybody. So you would probably be looking for somebody who lives in Mrs. Wilson's district now to run to hold the remainder of her term. A better explanation might be with Mr. Holcomb. He's filling a term on there, so you're filling a 2024 term, but because the way it's working, he's going to have to fill in. Whoever gets that seat is filling it to 2024 because
Okay,
that's the
so
remainder
they
of
would
that seat.
essentially have kind of a special election to fill that 2-year term.
From the people the same people that would have elected Mrs. Wilson. That's where it gets complicated.
Well, but the people of District 5 didn't elect Miss Wilson because that was under the at-large system.
But you're not filling because the 2020 District 5 is not due to be filled until 2024. So you're doing somebody to fill the remainder of Mrs. Wilson's term that she was originally.
So they wouldn't
elected.
necessarily have to live in District 5?
I believe that would be whoever lived in the area closely approximating where Mrs. Wilson lived when she was elected. I think
Okay,
that's how that
because we've talked about how, school board needs to mirror city council and what they do, and it's been said that we can't fill any empty seats that are in 2024, but in this situation, it looks like we could. If we have empty voting districts in the school board, as we do on that next slide, we have empty districts, we don't have any incumbents in them, and they're not open until 2024, then since city council would fill an empty seat, why wouldn't the school board fill?
But you're not filling it. It'd be
Or
more
an empty
equivalent
position.
to Mrs. Riggs. Let's look at Mrs. Riggs as 2024. If Mrs. Riggs were to leave her term into 2024, then.
But that's a 2022 district. I'm talking about 2024
But
districts.
2024 districts don't exist until 2024.
Correct.
They don't run for election. You have people that are on your elected board till that time period, but nobody's been elected to 1, 3, 5, 7 and the at-large position because they won't be until the 2024 election.
But but city council has someone filling those spots. So we have to be similar to city council, but we're not, because we don't have representatives filling the same districts they do.
And that is an interpretation that would have to be made, and that's one of the issues here. if your assumption is that they have been elected to those districts, they built the districts out, the special masters districts based on where sitting school board member, so I'm sorry, city currently elected city council members live. And it's not 100% that way, but that's sort of where they were looking at there. But you're assuming that people who currently live in 1, 3, 5, 7, and the at-large position they're not elected to those districts because those districts don't actually exist until 2024. It's how I interpret that, but it's not that, again, it's not 100% clear.
Okay, I'll let someone else go.
Ms. Owens.
Ms. Owens.
Thank you. And I think Cammie has kind of answered my initial question, and I just want to make sure that I'm kind of clear with that. So based on all of these districts being brand-new district, that means that when they run in 2022, for instance, there won't be any incumbents listed on the ballot because nobody has ever been elected to those new districts. Is that correct? They're not incumbents?
That is what I think should happen. I can't tell you what the register would do, but yes.
They don't list incumbents in.
Okay.
Yeah,
That's,
my interpretation is they're all brand new districts, and so how are they listed? That's the registrar's office.
okay, and so I would assume then the same would be true in 2024 when those elections take place. Those will be the first time anybody has been elected into those positions, and so there would be no incumbents listed on those ballots either?
Again, that's the voter registrar's office doing it. I would assume that's them, but I can't tell you how she would write that. She'll get directions.
The incumbent, okay, then maybe it's not an issue because there's no incumbents.
Okay.
Is that it for now, Ms. Owens?
That's it for this moment, yep.
I think, I'm up next, so I think it bears repeating though, because as I look out into the audience, I see some people like still struggling. So if you look at the city council sheet there, the special master actually drew each city council member into a district. So none of them are opposed. They're all incumbents in that district. If you look at, you see Branch, he was filling in, he was appointed. And so in this year, in 2022, Henley, somebody in District 4, somebody in District 6, Jones, Moss, and Rouse are all up for election. And if they all win, then they actually represent District 2, District 4, 6, 8, 9, and 10. Or whoever wins that seat literally represents those districts. So if you go back to, and then the other people who are up in 2024, they still represent everybody basically because those districts are not up yet. So they're basically still on the council, but they are not assigned to a district yet. And so in 2024, districts 1, 3, 5, 7, and the at-large mayor seat, they will run, which puts everybody in compliance for January 1st start date, basically. January 1st, 2025, we will all be in compliance and every district will have a representative. For both school board and city council. So that we will mirror image voting with the city council. So what they're doing, we do. And so this year, if you look up again, you can still look at city council and put everybody's names in. District 2, Melnick is up. District 4, you're right. Nobody in District 4, but she didn't separate them the same. So Felton is up, Rye is up. Weems, Holt, and Hughes all are in the same district. So in this case, what has to happen here is the three of them can either run against each other or two will have to bow out because there is no at-large seat before. So Holtz and Hughes had at-large seats. Those don't exist anymore. So we didn't have the luxury of having our names drawn into a district. So we're not all incumbents, right? City council all got to be incumbents, and that's the difference. And what they were saying earlier about Melnick and Riggs as an example, I'm up this year. If I choose to run for reelection, and I win, I will hold District 2 until 2026. But Mrs. Riggs, who is not up until 2024, is actually out unless she chooses to run at large in 2024 when there will be an at-large seat. Now, the caveat to that is Mrs. Riggs can say, well, I want to run again, so I'm going to run against Mrs. Melnick. And if she wins, she holds the seat till 2026. Then we have to back up and we have to find a replacement for her because she's technically an elected official until 2024. And so that's right. Then we'd have to fill her seat because she would have won and her seat would, by appointment, we'd have to appoint. So this is, it's complicated and it's hard. I mean, it's not hard to explain. It's just a lot of moving parts. And I think it bears repeating that we were not named in the suit. So we are just waiting and we have to sit and wait. And so right now, as Mrs. Linetti stated, Judge Jackson ruled, City Council appealed, they lost that appeal. And so, we could be moving forward, but now they are appealing again. And so we have to sit and wait and see what happens after that appeal to the Fourth Circuit, correct?
Clarify, it's their first appeal. The district court, the trial court ruled,
Okay.
and so now they've taken their first appeal to the Fourth Circuit Court of Appeals.
So here we sit, and by law, we have to mirror City Council. And I think that, at least I'll only speak for myself, that I thought that it was important to say to the public, by law, we're supposed to mirror, and we should follow the law and mirror City Council. And that is what the resolution states, just that we want to follow the law because we really have no say. We were not named in the suit. And with that, Mrs. Anderson is next.
And then we have Mrs. Weems, okay.
So one of the things that we're faced with, well, let's face the facts. There is a fact that we must match City Council with 11 members. That is the statute and how the statute is written in our state law. Also with our city charter. We also must mirror City Council with our elections. That's part of our state law, state code. State statute says that sitting board members or city council members can complete their terms when they're zoned out of their regions. So those are the things that we're faced with and what we're looking at today. When we have to mirror what city council does, then it's important that we know exactly what city council is doing. And so that's why it's important that we saw the list of city council districts that are up for election, and now we're also looking at those same districts for school board. And that's where we are right now. So just wanted to point that out and make sure that everybody understands that it's, we're not trying to do anything, in my opinion, what we want to do tonight is we're not trying to do anything different. We're just following the law tonight. We're going to try to follow the law.
Mrs. Melnick, if you could go ahead and name the cue. Just put your mic on, it's easier.
Okay, so Cammie, can you clarify this for me? So let's go down here. Say Ms. Melnick runs and wins. Ms. Riggs wants to stay on the board and finish her until 2024, and then she'll just decide what she's going to do in 2 years. But for now, she's just going to stay. She's not assigned to any district, she's just
She is the
representing
Centerville, that's your right, sorry. She's the Centerville representative for the school board, because that's what she was elected
that
to
was
be.
previous elected, but she's not assigned to District 4 or District 7. She's just there because she was elected 2 years ago, or recently, okay. Okay, so Melnick is gonna be on it, Riggs will be on it, and then, let's say Ms. Felton runs and she wins, and then Ms. Anderson's gonna do what Ms. Anderson's just gonna hang, because, until
She was at
24.
large.
Okay, so that's 4 members. And so, do we then say no one can run in District 4? District 4 is not available at all in 2022?
No, it has to be, no, it is up.
Okay, so we've got.
District 4 and
okay.
10 absolutely will be
Okay,
new
so we've
members.
got Ms. Melnick on the board, because she's gonna win. We've got Ms. Riggs, because she's hanging tight. We've got Mr. X that decides to run for District 4 and win, so that's 3 people. Then we've got Ms. Felton, she's gonna win. And then we've got Ms. Anderson's hanging tight, so that's 5. And then let's say Ms. Rye runs and wins, that's 6. And then let's say Ms. Weems, by some lucky chance, hopefully wins, that's 7. And then let's say Ms. Manning hangs tight, that's 8. Somebody else, Ms. Smith runs in District 10, wins, that's 9. Ms. Franklin gets to stay on, that's 10. Ms. Owen stays on, that's 11. So District 5, somebody runs, that's 12.
No, not till 2024.
Oh,
Okay, so District 5 is not till 2024.
Peter's
Technically, District 1, 3, 5, 7, and the new at-large position
Okay.
are not till 2024.
Okay, but how many did we have so far?
It'll be 11. There
It'll be
wouldn't be any more
11.
than,
So we
you can't
have
have more than 11 with this.
Okay, and then Ms. Hughes and Ms. Holtz would decide if they run or whatever, and then the others aren't up till 2024.
Only one person with District 9,
Yeah,
so-
only one person can run in District 9.
but one person, Mrs. Manning, can choose
Okay.
to stay on. But she's not representing District 9. If Mrs. Manning stays on, she's not representing District 9, she's representing the position she was initially elected to. So you can't have more, you're gonna elect 6 this time and 6 in 6 in this time, 5 in 2024. So the maximum you're going to have is 6 people in district positions. You will have 3 people because you have, remember, who carry over, and that's not the best term, but it's a carryover. But they're in the same situation that Mrs. Franklin and Mrs. Owens are. It just so happens that Ms. Franklin and Mrs. Owens currently live in districts of there, but they're not technically elected to those districts at the time because they don't have the opportunity to be elected to those districts until 2024. So the max you would have would be 11 people.
Okay, so, and then in 2024, Ms. Franklin, Ms. Owens would decide to run again if they so choose. And then whoever in District 5, District 7, or at large, and then if one of those who was hanging tight over on the left just happens to live in District 5 or 7, then they would obviously run in that district.
Mhm.
Okay.
I'm going to point out a complication.
Or at large.
Yeah, at large, but if you live in 5 or 7, then it's going to get a little complicated. But yes, we can look at that problem.
So if I live in District 2, I can't run
Unless you run at large.
unless I run at large.
Right, because she would still have 2 years on her term.
Right,
Correct.
exactly. If I wanted to run for my district that I'm being put in, I'd have to get off the board.
Yeah.
Drop my seat and run in the fall.
And anybody in the left-hand column, the 2022, if you won, whoever got the run
Well,
position, if they
well,
run for at
Excuse
large,
me, wait a minute, we have
Sorry.
too many people talking.
Sorry. I wouldn't drop my seat, I'd keep it, but if I wanted to represent the new District 2, I would have to run.
in
Okay?
2022, because it will not become open again until 2026.
Which is what we use as the example.
Okay. I just wanted to bring that out, especially for the public, because, yeah, it's just, it is complicated and confusing. And
If you follow this plan, you're not going to result in any more than 11 people. But if for some reason you think you have a reason to have more than that, I do think at that point you need somebody to say, whether that's a court or a general assembly, we want something else, because that is not a natural interpretation or logical interpretation for the law. So if there was a reason somebody thought you needed more, then yes, you need either the law change or some court to agree with you, because when we look at the law, legal counsel look at the law, we think you're required to match up as close as possible to the city council's situation. But if you thought for some reason you need to have the 2024 people should just stay on and you should elect everybody, I do think you have to go there because I don't think that the registrar is naturally going to say there should be 11 elections next year, because that's not what city council is doing. So I think you need, that definitely needs another body, either General Assembly or a court, to tell you that that would be okay to do.
I have one more. But the difference is that city councils was so conveniently drawn. I mean, that's the huge.
But with all due respect,
That
you
is-
all had the
that's
right to be
huge-
able, it was
that's the huge
public.
difference. So I don't think that we have to all of a sudden say we have to be exactly like city council, because city councils was conveniently drawn. I mean, it lucked out
Well,
that way.
And
But-
the,
But there were
So-
public hearings and everybody had the right to go over and participate in
I
them,
know.
so.
But I think that's our argument, that if we want it differently, we can say, yeah, it's just, you can't even compare, you really can't compare the two because of the way the lines were drawn around each city council member.
And my
Yeah, I
ongoing
mean,
concern with that is
puts
that,
it in a different
as a
ballgame.
court would say, why didn't you take action to work with your body? Why didn't you do something about the time to ask? Not that you would have intervened in the suit, but you had the same right the public did, or you could have taken action at the time period. That becomes a problem. So we would have to go after the fact and say, and it may be that we did not know until the final districts came out what the situation was going to be, but you absolutely had the right to be involved, the same as the public did when they were going through the hearings and making the proposals on the districts.
so I just had two follow-ups, if I may. Yes, the school board did wind up in a more unique situation in that 4 members wound up very clustered within in a small geographic area, and really because 3 of them are at large, and that can happen, and so that's what makes that different. So just to recap, and thank you for Carolyn for leading us through this too, that in the first column, and Mrs. Melnick as well, in the first column, we wind up with 6 and 3 carryovers, because we can't come up with a better word. The second column, there's 2 now, and then the 3 carryovers equal districts 5, 6, and at large. So that's how that math works out there. Just wanted to note that. So we'll go on with our speakers.
All
Thank
right,
you.
Ms. Hughes.
So I think Ms. Melnick's explanation was mostly correct, but it would seem that districts 5, 7, and at large would be running in 2022 for 2-year terms if it is to mirror. And City Council will be having a special election because Rocky Holcomb in District 1 will be running to fill that term. So that will be going on. What I don't find okay is that, and it's sounding like what you're planning on doing is having Ms. Riggs, Ms. Anderson, and Ms. Weems fill those 3 seats, which you should not be doing because it actually blocks people who live in those districts to be able to represent
I know
that district.
No, that they don't get, those elections aren't up till 2024. I was just pointing out it
Well,
just.
you're guessing that they won't be. It is just as possible that they will be elections where people run for 2 years. They'll have 2-year terms so that it would sync up with city council, so that by 2024, you can stop shaking your head. I don't sit here and shake my head when you're talking.
Please.
So at 2024, it would sync up, which would have, the thing we talked about earlier was by 2025, everything has to be aligned. So by that 2024 election, when people took office in 2025, everything would sync up and mirror city council. But I feel like you're trying to put those in there to block people from running. And I think that's what this resolution is about.
Ms. Linetti.
One clarification, under your new system, which will be, it's a ward system, you have to live in District 5 or District 7 to be able to run for those in 2024. So, if any of you move over there and it's legitimate, then you could possibly run for those positions. And I will point out, you do have at-large people that are still on the board. For your at-large position, you have 2024 people that are at large. So there's an argument you have at large. I agree you've got the situation with 5 and 7, but you're making an assumption, and this is what's just never been clarified. The fact that you live in what is going to be a future, recognized future district, does that mean you're actually elected to that district? That's not been clarified by a court order or anything. So you're making an assumption. I can't tell you that Mrs. Franklin is representing District 1. She happens to live there. And obviously, if she still lives there in 2024, she won't. But I can't tell you that she is now the District 1 person because she will not be able to put that on a business card until she wins an election after 2024. So Mrs. Franklin, Mrs. Owens live there, but they don't technically represent them. They will, or whoever wins those elections 2024 will. So I know what you're saying. And again, this is the problem we've all had. How do we interpret what happens in 2024? We think the logical interpretation is it's a staggered system that will fully come into compliance on January 1st. Now, again, could somebody say, I feel like I need to have somebody currently living in my District 5 or 7? That's a possibility. They would have to do that. I don't think that you get to do anything about that other than we're just trying to clarify. We're trying to say, is anybody else paying attention? Can the law help it? Can somebody fix the law? Take a look at it. And that's why you proposed a bill in the General Assembly. And the proposal that you came up with was look at what City Council's doing. Again, it's not that you can't do a different law, but who's going to do that? Is it going to be the General Assembly? Is it going to be a court? I don't know that you have a good basis to go into a court to do that. You can go to the General Assembly and say, hey, General Assembly, can you help solve this problem for us?
But the point I was making is that in District 1 and District 3, even though Ms. Owens and Ms. Franklin were both elected at large, it seems appropriate that they are placeholders for those districts because they actually live there. Whereas 5 and 7, there is no one here to be an appropriate placeholder for those districts because none of us live there. And so to put somebody who lives outside of that district to hold it as a placeholder is blocking people who live in that district to elect their own representative.
And I understand what your argument is, that maybe they deserve now in 2022 to have an election. That is not what the court put in there, but if you're saying that, then I think somebody needs to clarify that. So the question is, you're back to where we were before. Who clarifies this? We made an attempt with something the General Assembly to try to resolve it. The General Assembly could enact a law that clarifies what you do in these circumstances.
Well, they didn't have to clarify because City Council had no conflict. That's why it wasn't, none of this is clarified, because it didn't have to be.
So we're just victims of circumstance, technically. All right, I have Miss Owens, then Miss Riggs.
Okay, and I have, I guess more so 2 comments. I don't know that they're really a question. But, well, maybe it is a question. My understanding from our conversations today is that when we look at these lists and we see empty 5, 7, and perhaps at large on the 2024 side, that when the question comes up, well, who represents me? If I live in District 5 and you're saying, who represents me? My understanding about that answer is it's whoever you voted for last election. That person still represents you. So if I lived in District 5 and I voted for, I don't know who that would have been, but I voted for Felton, well, Anderson, then Anderson is still on the board. I know Anderson was our at-large, whoever. I voted for somebody when I lived in District 5. That person is still going to be here. That's the person, if you wanted to have a who represents me, who do I want to call specifically, that's who you're going to call. You're going to call who you elected or who was in that position if you didn't vote for them. But, and that stagger step in, so this 2022, people in 2, 4, 6, 8, 9, and 10 are going to vote in somebody new. People in 1, 3, 5, 7, and that at large, I'm not necessarily the representative for 3. I still represent Rose Hall District. That's what I was elected to represent. If they live in Rose Hall District, they can obviously still contact me. We know that we all make decisions on behalf of all the students and families in the city. But if they are looking for the person specifically who they want to contact, my understanding is that those positions that were elected in are still in until 2024. So there's not really people who are left without representation. The person that they voted for or voted in when that election happened is still present, and that's who's representing them until that next election cycle. My other concern, I guess, if clarification or if the General Assembly puts something different in that says we want to have these extra elections that run for 2 years, so that we can put people in 5, 7, or whatever districts that they would want to add in there and give us an extra 4 members or 5 members on our board, besides the fact that this board is enough drama with 11 people. Outside of that, I don't think it's fair for taxpayers who, granted, school board stipend in Virginia Beach is lower than any of their other sister cities, but $12,000 a year times another 5 members on the board times another 2 years just put $100,000 tax burden to our taxpayers when they are still ultimately represented by the person that they elected. And I don't think that that's what we need right now with financial. There's never a time when we need another 100,000, but so that would be a concern to me as well. And that's kind of the base price before you even get to whatever other things need to be added to make another 5 or 6 people in here work for 2 years. I think everybody has representation in the current system. I think this system allows for us to continue to mirror city council. And I think that that's important and less confusing, even though it's still confusing, than what it would be trying to add another 5 people in for 2 years and having all the additional nuances that go with that. So that's why I think it's important that as a board, we make a decision on what we'd like to see. And personally, I would like to see us move forward with the way the law is written, and not have, additional people and additional taxpayer burden.
Kim?
Okay, it is, Riggs.
Mrs. Riggs?
I just wanted to respond to you, Mrs. Williams. I asked a city council member the same thing. Why? I mean, you guys all ended up it was divided up very well, okay? What happened to us? And this person said, oh, you could have spoke? Really? To the courts, the suit wasn't for the school board. How could we have spoken? And she said, well, there were a couple city council members that spoke and it worked it out. Well, I just want to explain District 2. It goes a little bump over my street. Just a little bump. Puts me in 2 instead of in my old Centerville.
Which was?
Which is 7 now. And I'm like, that's crazy. Why did look how it's affecting us. But again, the lawsuit was for city council, not school board. So anyway, it's just, it's very confusing and it's really kind of made a mess, but sorry.
Ms. Franklin.
And I just wanted to remind, the reason that Mr. Holcomb is having to run again in 22 is because Jessica Abbott had resigned from the city council. And so he was appointed until 2022, where he would have to run again to fill her seat because she was elected until 2024. And so that's the reason that he is having to run under the umbrella of the 2024 elections, is because he has to get elected to that seat again. The one thing that I just also, I really mirror a lot of what Ms. Owens has said as well, because I know that personally I answer constituents from all over the district. So, it's not just from the Kempsville area where I was elected. So I would agree that no matter who is going to be sitting in, I think we say carryover, is that the word we're using now? As a carryover, is going to represent both 5, 7, and the at-large as well. And so I also have an issue with additional taxpayer burden as well in terms of additional stipends. So, I think that the resolution is smart. It's logical. It follows city council. It follows the current laws and the rules that we have. And so I think that is a proper resolution.
Ms. Manning.
Thank you. I have a couple questions, Cammie. Well, first thing, I want to clarify something. So, for example, I'm in District 9. I happen to live in District 9. I can stay on the board until 2024, but if I decide I want District 9. I want to be the District 9 rep. If I run, I give up my,
2024 term.
my right to stay on the board, whether I win or lose.
No,
I give it up.
You don't give it up.
If you lose, you're still 2024. If you win, you're now District
Okay,
9.
so it's my understanding, there's redistricting laws that I've read that, and I don't know if redistricting laws applies here because there's also a judge's order, but we're not under the judge's order. We're under probably something different since we're not following the judge because we weren't a party to the lawsuit. The redistricting laws that I have read is that you are grandfathered in and you get to keep your position unless you decide to run for that other seat, that new seat that you've been redistricted in. That's the redistricting law that I read.
There are some that say that, and that's the
Okay.
clarification that needs to be made in the legislation or termination by a court, is that
So it's
sometimes
not
you give it
given
up.
if I run for District 9 that I'm going to keep my 2024 position.
But
even if I
Mrs. Linetti
lose.
has cited the state code that says city and school board members complete terms regardless of residency, and there were a few
Right,
other
we can
things
complete
cited.
it, but if you decide to run for a different position, if the legislation or the laws, the redistricting laws that I've read state that you can't retain that right.
I'm not sure that's a full explanation. I'd have to go back and look at that because I think
Okay.
there are situations where that doesn't exist. If sometimes with redistricting, you create more or less districts than you had before. So that in this situation, you're coming out with the same number of positions that you had before. Sometimes with the redistricting, you get less or more districts, and that's what the confusion is.
So who would need to clarify? Would that be a Department of Elections? Would that be
I can
an
go
Attorney
back and look
General?
at that. We can go have to look at that. What would happen on there, and I'd say get outside counsel also to write you to that. But I think this is why one of the reasons we were looking at additional legislation is it's not a perfect fit with redistricting because redistricting can change the amount of districts that you have, whereas this is not what happened here with you retain the same amount of people. So it's not a perfect carryover to look at the redistricting law on this.
Okay, can we go back to the city council
And-
slide again?
And Mrs. Manning, can I just say, that protection perhaps could be worked into the bill, if it's
Yes.
not already? Because that's something that there's no
so-
dispute on here.
So in the judge's order, did the judge say, for example, that Mr. Berlucci does not represent District 3?
No, what the judge actually said is, Special Master, give me a recommendation on a plan for what your district should look at. He's not appointing district. It might be confusing the way I put them here. I'm trying to accomplish two things at one time for you to see where the people are because why we're having a complaint. The judge just said you have to have District 2, you have to have 11, you have to have 10 districts and one at-large person on there. And the Special Master took the plans that had been provided by the plaintiffs and defendants, created the 10 districts, the boundaries on those 10 districts. Those districts are up. The reason I put the names there is that's how he chose which ones would be the 2022 elections of 2024 because he knew their terms were up. So, but he didn't say Henley, anybody in there. He just said, you now have 10 districts, Virginia Beach, and an at-large member. And the districts are what the boundaries have been described in the Special Master's report.
So according to the judge's order, there's no representation in Districts 1, 3, 5, 7, and at-large. Is that what you're saying? Or
I think you're getting hung up on the representation. The city of Virginia Beach is entitled to 11 elected members. I'm just going to use city council for now. The voters will be entitled to elect people to these districts 2, 4, 6, 8, 9, and 10. The people that live in those districts will be allowed to elect people to represent them who will take office on January 1st, 2023. The rest of you remain on just like you were before as the remaining people. There are 5 people that continue to do it, but the judge did not order that those elections failed. So on at the 2024 elections, the citizens in 1, 3, 5, 7 will be allowed to represent like people from those resident districts. And then everybody in the city gets the opportunity to go for the mayor position at that point. So you're mixing representation with whether you represent. You still have 5 members. It's just it didn't all come. The judge did not say all 11 positions are up at once. It just wasn't what he ordered.
okay, It has been stated a number of times that we must always match city council elections, but there have been times when we don't. For example, if we had to have a special election to fill a seat, if a board member was removed, we had a special election for a district seat when city council did not. So we don't always mirror city council.
Well, I would,
so.
that's what Mrs. Rye was saying, what I said is you have to have people in these seats, and you have to have if a city council has a position, you have to have equivalent school board position. It has to be a 4-year term that starts the same time that city council terms. If you had special elections to fill people in, and, we've had many over the years, that's a different situation. What we're talking about is if there's 11 city council members, there are to be 11 school board members, and they're supposed to be 4-year terms, and those 4-year terms start at the same time for both city council and school board holding that position.
So I think we can probably all agree that this has kind of put the school board as a body kind of in an awkward situation here, because there really are no right answers here. There really aren't. And, I feel really uncomfortable as an elected person who campaigns on my own. We can't bring political stuff in here as far as our campaigns go. I have a really hard time as a body advocating for what could be beneficial for this person or that person, because these things we're discussing, it's going to benefit certain board members over others. It really is. So the decision that's going to be made, if a vote is taken, it is going to benefit politically certain board members over other board members. What's decided, certain board members could lose their seats, not even have an option to continue on. Other board members may not. So I don't think this should be, excuse me? Did you have a comment?
No, she was just asking about
Okay.
who was next in queue.
So I just specifically think that this should not be something that we weigh in on, because I think I think that it gives us an advantage or disadvantage in some instances. I just don't think that it is under our purview to do that. I think this should be left up to City Council and the Department of Elections. City Council is the governing body on this topic, and the Department of Elections are the ones that need to make sure that we're in compliance with the law and the judge's orders. And I would just feel more comfortable. And I'd like to hear from the public and what the public thinks. Does the public think that the school board should be even be having these conversations right now? I would like to know what the public thinks and how they view it. Because this is the first time that the public has been brought into our conversations. So I really feel that that's the direction we should go. And I'm still not even sure how I feel about all the different options. I've got different viewpoints on those.
Okay, I was next, and then Mrs. Felton. Ms. Toniato, can you put the slide back up for school board? So, yeah, that, okay. So we tend to make things personal, and the truth is this is not personal. This is about elections, and there was a ruling by a judge. And if this slide doesn't show you exactly why we need 10 districts and 1 at large, I don't know what does. So District 9 alone, right now, has 4 members of this board that can all ride together in carpool. So 4 members of this board live in District 9, which, if you just look at that logically, so many districts right now don't have representation. That's why this law was so important. It's going to give each district a representative and 1 at large from anywhere. And that's fair. And no one's losing a seat in 2022. Nobody's losing a seat. Everybody has the ability to run in their newly formed district. Unfortunately, District 9 took the hit. And that's how we should all refer to these now, as districts, not names. District 9 took the largest hit. And they have 3 people in that district that either have to run against each other or have to wait until an at-large seat is up. That stinks. It does. But that's the way it's... But that's the way it happened. And so, and I just want to make this point. No one is losing a seat and no one is losing a term. Everyone gets to finish out their term. Ms. Felton?
And I've been, now Siri's wanting to talk to me. I apologize immensely, I do. I just like. To apologize.
Oh, God.
Do
we need to remove the phone from the room?
No, I want to shut it off. There we go. For being disobedient. Okay. I just like to speak to the public that are hearing us, and I do apologize. Got us all off. But how do we get here? And we've talked a lot about the city council and what was done to them. And yes, we know that it was a civil lawsuit put forth, and we were not directly, but it was a city council. But I just had to read some of what it was said in the opinion by Judge Jackson, the federal Judge Jackson. He said, by a proponents of the evidence, the plaintiffs have demonstrated that at-large system of elections for the City Beach City Council denies Hispanics, African Americans, and Asian equal access to the electoral and political process in contraventions of Section 2 of the Voting Rights Act. Accordingly, it is hereby declared that Virginia Beach at-large method of election is illegal and cannot be enforced in future elections. It is therefore ordered that any further use of the at-large system of election for the Virginia Beach City Council is hereby enjoined. Order that the city of Virginia Beach shall not adopt any system of election for members of its city council that does not comply with Section 2 of the Voting Rights Act. Order that the city of Virginia Beach shall not implement or utilize any practice, policy, procedures, or other action that results in the delusion of minorities' participation in the Electoral Act. And it goes on and on. It was a federal judge that made this opinion and decided that the city council had to move forward and do these things by means that the charter that we are under with city council says that we have to mirror what city council does. Does it put a lot of us in a lot of precarious positions? Yes, it does. We find ourselves, I didn't even know that I lived that close to Miss Anderson. I'm in the heart of SeaTac, in the heart of SeaTac, and they got me up there with Miss Anderson. How in the world? You're right, Miss Williams. It looks convenient for city council, and it's acting in that part. But I would say, we are under the auspices of a federal law. And it's not that any of us set out to do this to anyone. And I just feel that at this juncture of the whole situation, that we were not asked to come to the table by city council. And I myself reached out to many of them to ask them what was the effect that this was going to have on us. And they but shooed me away until they got themselves together. Mm-hmm. We are really thinking about where we're going to go. And not only that, I asked even our legislators, the delegates, to come and talk to us, to let us know what you're doing so that we can come to the table. We have not been asked to come to any table. So, I felt that I need to be protected, or I need to have a voice still. Because I don't only represent just a few constituents. I represent all of the students. They're not constituents. None of them are party related. When I see them and relate with them, I represent the students. And that is what the focus is on my mind at this particular time. So I'm at a juncture now that I need to uphold a federal law, not some fly-by-night or what they're saying that we need to do and other things. But this is a federal law that has us at a stalemate, and we're waiting. And until that appeal come through, we are still at the mercy of that federal law and the court. But if anything else is going to come up and go forward, I want to make sure whatever that is, or whatever legislative or whatever resolution it is, that is somehow still giving me a voice as to where I'm going to go with this particular election. We are still waiting. We are held holders, and I hate to use the word hostage, about even getting our petitions out because we don't know really what district we're in and how we're going to do that. Who's there? So we are all in a quandary. We are all under the subject of this federal law, and it is holding us still until things are done completely. I just wanted to make that statement, and I've been hearing a lot of things, but this opinion is 133 pages long, and I went through most of it, and then I got down to the conclusion. I mean, I was reading it, and this judge, if you go through this federal opinion that he has named at least 20 cases, at least 20 rulings that makes this opinion so tight. I'd like to see how the appeal is going to come out. It can be appealing for a long time, but it is a well-written, it's a tight opinion, and he didn't leave anything out. He went into depths of talking about how discriminatory the working relationship and job giving are in the city of Virginia Beach. He went that deep, but not going there. I just want to say that I'm a school board member. I love what I do, and I look forward to representing all of my students in our 88 pieces of institution of education that we have in the city of Virginia Beach. But right now, where I see it, we are under the law of this federal judge. Thank you.
Ms. Riggs?
So it's clear, I guess, it's clear what we have to do. So my question is to Ms. Linetti, what do we do next? What do we do?
Well, again, you had some discussions with the outside counsel on it. What you do have pending at the moment is the bill in the General Assembly that we're trying to get the language correct. Can we, as you can hear, we have all kinds of interpretations. We are all struggling. So we're trying to get some clarification of the law. It would be easiest if a law was passed clarifying what to do there. So you have something in the General Assembly. As we mentioned before, our concern is that crossover is on February 15th. This will need to get up to committee before February 15th if it has any chance of surviving. So it's got to get through that part of it. So we've got to deal with what to do with the bill in the General Assembly, what we think the language needs to say. And then obviously if it goes to the next House, then we will have to make sure we're working through that it gets through clarified and doesn't get changed over there. So that is current at the moment. If this does not go through, then we're back to where we've been all along, is how do we interpret this? At that point, as we mentioned before, you're kind of stuck. So it wouldn't be you going to a court that I could see doing something about this, because you as a board don't have your chances to fix the legislation to clarify ambiguity in the law. Otherwise, you're going to have to wait and see what happens, and then you're going to, I don't know which body would be sued, but then we would have to deal with that. And we talked through some of those, we talked in closed session about who would represent you and how that would happen. So there are potential there. But what you do have pending at this moment is the bill in the General Assembly, which you do need to pay attention to and figure out what you want to do with.
Which we don't know what that bill says yet, because it's not, the final bill has.
HB 1031 is in.
Okay.
That is the bill at the moment that has been introduced. Now, it could be changed, and there's been talk about changing it. So that is what you have to deal with. If it's going to change, it will happen most likely in committee in between now and February 15th. So it'll have to be clear at that point. So you've got this short time period where you have to make sure, if you're interested in this bill, you get wording that you want and explain to the committee what you want to help them draft you the bill. Otherwise, they'll draft it for you, or it'll die in committee and you will not have anything coming out of the General Assembly, which will throw you back to what's going to happen, and that's where it gets more complicated.
So that bill would go in, it would come in with our request, the school board's request. So we're,
It's been drafted. It has not been assigned to a committee, is my
Right.
understanding. It will need to be assigned to a committee, and it'll need to be heard. Again, you've got 14 days to get that done.
so basically, we would want it to say that we're following the charter and following the, I guess, I'm not sure. Do we want to
One
follow city
proposal-
council? I mean, or do we want to
What-
make it more complicated like we've made it tonight?
That's your choice. And one proposal was, school board members approached me last week and said, how could we write something to explain that we want to be consistent with what we believe the law says we have to do? And that's where a draft resolution was proposed. That's not the only way you can to do that, but that would be one way you would ask, this is what a majority of the school board is asking, so that it could be used with the General Assembly if they're doing the bill. If you want to do something else, you have to redraft that language, which again, you need to move on that because your time in the General Assembly is quickly running out.
So, do we look at that
If I-
resolution tonight?
If I may, right, so there is a draft resolution, and we'll see if we can, do we have?
Somebody would need to introduce it. We have
No,
a
but I mean,
copy
do
of
we
it.
have the capacity to show it on the screen?
We did, we had
So-
it.
There's twofold reasons for this. We've been approached by both city council to say that, the school board really has to come to some consensus on what it needs, what it is asking. And even outside counsel affirmed that a consensus from the school board would benefit the legislation piece of this, that we need to make it, we need to be clear on what we're asking, so that, in the words here, a statement from the body would prescribe would also help prescribe eventually the Board of Elections. I mean, there's many different levels of government that want to know what this body is asking.
So I think at this
So-
point, if you want that resolution, I think somebody needs to move it. I have it. I can put it up electronically, and it was obviously, it's in the agenda package, so everybody's had an opportunity to see it since last week.
So before we do that, though, Ms. Weems is in the queue and Mrs. Hughes does have a question. Ms. Weems.
Okay, thank you. I think that I have no problem of looking at the different ideas out there and whatever legislation we have, although we know that it's being changed as we speak, I guess. I think it's very important, though, for me to hear from the public. Our citizens have some great ideas, and none of y'all were around 20 years ago when there was this one president of the Bayside High School PTA named Carolyn Weems who came before this board and argued the whole redistricting plan. Okay, I was the only tiny voice that came and said, you shouldn't move Thorogood to Princess Anne, you should move them to Bayside High School. And I came with my numbers, my facts. Donald Greer took that, and it became the Weems plan because of one citizen. Okay, so he was like, "This is our plan, and this is the Weems plan." It didn't pass, even though it was a good plan. But they listened to the public, and they respected that one person had an idea. We've had people come and change our whole thing about recess because 2 or 3 citizens came and had an idea. Someone might come in the next few days and see this after we've discussed it, and a light bulb goes off with them and says, oh my goodness, y'all are making it way too difficult. Why don't you try this? Or I would like you to see this. This is a very political decision. It involves government, and the people are our government. So I want to hear from them. I will not vote on anything tonight. Okay, we have time. Crossover's not till the 15th. We can get some input from the public, or the public may just, most of them, if they say, don't do anything because y'all don't have, any place to go, you just got to wait and see. It's just too much for me to even digest. There's so much going on and so many things going on. But I think that we have got to listen to the public tonight. I am not comfortable on voting on anything tonight. We can look at all the ideas, get it out there, let the public see them, and then we may just get several great ideas. Or we may end up not getting some ideas, but we owe it to the public to listen to them, especially after they've gotten to see this and how they can digest it. I'm not going to vote on any political decision that we make tonight without input from our public, and I really do think we have time. We have nothing that needs to be said or voted on tonight. We're not going to agree on anything either. We're going to be sitting here changing 1,000 things because it's so complicated. But we have time. We can do this in the next 7 days, get something out, let the public see it, listen to input, and we can vote on it next week. So I urge my colleagues to do that.
Ms. Hughes.
I agree with everything Ms. Weems just said. That's not why I raised my hand, but I do. I just have a quick question for Ms. Rye. You said city council approached asking us about this. Who actually approached from city council?
Well, it's been stated that city council did not intend to take any action on this, so it was made, their leadership made clear to me that this was in our hands to reach a board consensus to move, to communicate with the legislature,
I'm just curious who the conversation was with.
with city council leadership
So,
You and the mayor?
and the vice mayor.
okay. I was just curious. Thank you.
And I was just,
Well, may I?
yeah, Cammie, so Mrs. Weems talked about school redistricting, which is so different than this. There's a law that goes along with this, but, so crossover's the 15th. It sounds like it's far away, but tomorrow's Wednesday. And they only operate Monday through Friday. So we have Wednesday, Thursday, Friday, and then Monday, Tuesday, Wednesday, Thursday, Friday of next week. And that's it. So it has to get through committee and it has to get to the floor. Let's just say tonight we pass this and it still doesn't make a difference and it doesn't get anywhere. Then where does that put us?
So if you pass the resolution tonight, and the General Assembly doesn't take action or it does something different than what you've asked, is that?
Well, I mean, we only have, if we wait until next week to hear from people about a law, that we're trying to follow a law, it's different than redistricting school lines, right? So if we
Yeah,
wait
this is a
until
matter of
next
legal
week,
compliance. So.
and if we wait until next week and decide that night, the 8th, then that only gives us Wednesday, Thursday, and Friday of next week to get it into committee and to get it to a vote on the floor. And so, I mean, we're at the end of the rope here. So we either do this tonight because there's a law that's governing all of this. This isn't political opinion. This is what we've been handed. Or what happens if we don't get anything to the General Assembly in time?
Then I'm assuming that Delegate Davis goes on with what he determines is the appropriate wording.
We don't know what that is. We were not a part of that. So we put a placeholder in, some benign language was written. All I know at this point is that there's been one school board member who has been in touch with Delegate Davis to work out something which is now evidently being amended. And we as a body were not privy to any of that. And so for that to go forward without a clear message from this board, from majority of this board, that's wrong. That is the opinion of one board member who did not share that information with this body. That's what I'm opposed to. Not being here and collectively having a majority of the board agree to basically a benign resolution that puts us back at our start date with that same benign language. There is a lot to lose here, and we will lose as a body without having a word. And all we want to do is mirror the law. That's it. Ms. Franklin and Ms. Manning.
Ms. Franklin, I'm sorry.
Okay. I have to say that I do actually, in terms of everything that I've heard tonight, I without hearing from the public yet, I do agree with the resolution that is in place. I have to say, though, just from the discussion we had, not only in closed session and in public, since it is really just our suggestion as a body, I have to say that I would prefer to vote on it after I have heard from the public, though. As Ms. Weems said, in regards to maybe there is a potential other suggestion out there. I do agree with the resolution as the best, answer for right now. But I don't see, since it is just a suggestion, again, as a body, that we don't change our policy on the way that we do our procedures to try to fast track a vote tonight. What I would think that we might be able to do, though, is, again, as individual members, maybe reach out to Delegate Davis's camp and let them know our opinions, and just relay our personal suggestions to Delegate Davis as, not from the body necessarily, but as constituents and as people who do have some opinions on the matter. So I just, I do agree with the resolution. I'm not sure that I agree with taking the vote tonight. So thank you.
Am I in the queue?
So, the board has been meeting on this topic in closed session for months and months. And we have known for months and months that legislation might be what we need to fix this problem. Months and months. Every single closed session, I have said, we need to bring this to the public. We need to bring this to the public. Oh, we're gonna, Miss Manning, we're gonna. We need to bring this to the public. I have said it every single meeting. And now all of a sudden we're at the deadline and we have to vote on something. That is not right. Poor planning on this board's part should not make the community suffer from being able to give a lack of input to us. Delegate Davis is a friend of mine. I speak to him a lot on a lot of different topics. And if he asks me my opinion on something, I'm going to give it to him. But I've never contacted him and said, here's the official position of the board and I'm speaking for the board. I think every board member here should be calling their legislators and telling them how they feel on topics. And I'm assuming many of you do speak with some of your legislator friends on a regular basis. And I'm sure that you've spoken to them about legislation that has come before them that affected education that the board had not voted on. Ms. Linetti had mentioned that she had submitted some draft legislation to Delegate Davis. I've not seen that draft legislation. I'd like to see what that initial legislation was because I don't even know what that is. I just, while legislation might be the fix, and I would hope that we could all come to a consensus on what that is, we really, really, really need the public input on this. And my colleagues have told me over and over and over again in closed session that you agreed with me that the public needed to give input on this. Almost every single one of you. And if you go back on your word on that, I believe that that is a lie. Thank you.
I have to respond to that. We haven't been having closed sessions every week. And each.
I didn't say
No,
every week. I said
but-
we've been having them for months, and we have.
And typically they were legal updates. So I do beg to
We have
differ with-
discussed in detail all the different plans, all the different options. We have spoken in great detail.
But these have been legal updates.
We have spoken in great detail of the different options that the public deserves to hear.
I was just going to ask if we go back to the resolution, please, if we could pull that up. Because it's been referenced so often, and now would be a good time to,
So do you want to make a motion as to somebody propose this, or you just want to look at this right now?
would you be able to read it aloud for the public?
Certainly. This title is Resolution Regarding Election Districts and Election Schedule for School Board of the City of Virginia Beach, Virginia. Whereas on December 22nd, 2021, the United States District Court for the Eastern District of Virginia issued a final order setting forth new election districts and election cycles for the City Council of the City of Virginia Beach, Virginia, but the order did not specifically address the school board. Semicolon, and whereas the court ordered election districts and election cycle results in some The court-ordered election district and election cycle result in some ambiguity regarding the election districts and election cycle for the currently elected school board members, semicolon, and whereas the Charter of the City of Virginia Beach, Virginia, Section 16.04A, election of school board members, states, in quotation, all board members shall be elected in the same manner and according to the same schedule that the council members are elected for terms of 4 years, period, end quotes, and whereas Code of Virginia, Section 22.1-57.3, Section A, states, quotation marks, elections of school board members in a county, city, or town shall be held to coincide with the elections for the members of the governing body of the county, city, or town at the regular general election in November or the regular general election in May, as the case may be, period, quotation marks, semicolon, and whereas Code of Virginia 22.1-53.3, Section B states, quotation marks, the terms of the members of the elected school board for any county, city, or town shall be the same as the terms of the members of the governing board for the county, city, or town. In any locality in which both school board and the governing body are elected from election districts as opposed to being elected wholly on an at-large basis, the elections of the school board member and the governing body member from the district shall be held simultaneously, ellipses, quotation marks, semicolon, and going to the next part of it. Whereas Code of Virginia 22.1.57b further states that, quotation marks, in any case in which school board members are elected from election districts as opposed to being elected from the county, city, or town at large, the election districts for the school board members shall be coterminous with the election districts for the county, city, or governing body, except as may be specifically provided for the election of school board members in a county, city, or town in which the governing body is elected at large, period, in parentheses, in quotation marks, semicolon, and whereas Code of Virginia, Section 22.176, Section A, states, ellipse, as it at its annual meeting at each school board shall elect one of its members as chairman, ellipse, in quotation marks. Accordingly, the Code of Virginia sets forth the procedure for electing a chairman for the school board, and the school board will comply with this law. Now, therefore, be it resolved, 1, that the school board intends to comply with the court order and applicable law and follow the same election districts and election cycle as the city council. 2, that the school board determines that it should have an at-large 11th member as the city council has. 3, that the school board elections in 2022 and 2024 will be for the same election districts or at-large position as the city council. 4, that school board members whose terms expire in 2024 will continue on the school board until the conclusion of their terms or until such time as they resign or are removed from office. 5, that the school board shall have the same number of elected members as the city council. So I think the rest is just the signature line.
So if you could go back to that, please. So I think, the resolved part, in effect, these all acknowledge the codes and the judge order and the charter that you outlined in your PowerPoint. These resolves.
Yes.
That basically have been imposed on us by a judge, even though he doesn't speak to these directly, but through his ruling, these other codes and laws come into play, and this is where we land with these 5. This is the assessment of what the judge order has ruled for city council.
This
In effect.
resolution aligns what the school board would be doing with what city council is going to be doing, and it sets forth the laws and the whereases that we think support that.
And I think there's a case to be made to convey this to the General Assembly sooner rather than later, so that we can move ahead with filling this gap, so that we don't hold up school board elections and we don't hold up the community and sitting board members who want to submit their petitions and have them certified. That's my comment. Mrs. Anderson?
I just want to speak to a couple of things. One of the reasons, because recently we've received several emails from the community stating that we we've been having these closed sessions and somebody got them to believe to believe for some reason that we were doing things nefarious in those closed session meetings and they were keeping things from the public. All those closed sessions that we had where we did discuss anything about redistricting or the districting were all meetings where we had our counsel giving us legal opinions. So we weren't trying to keep anything secret, but in the beginning, when we first had some of those closed sessions, City Council hadn't even received the ruling from the judge yet. And so they were very closed-mouthed about it, which they had to be. We were given opinions from our counsel, and so we were closed-mouthed about it because we felt like we needed to be closed-mouthed about it too, for the same reasons. Things were still in litigation. We weren't trying to keep anything from the public, and I think that needs to be made clear. Because there are a lot of members of the public who look at social media posts and believe what they're told on them. And you would think that people would know by now that everything you see on social media is not always 100% the truth. Sometimes people say certain things and they leave out part of it. And they lead people to believe certain things. So I'm not accusing anyone on this board of doing that. I hope that that's not happening. But at the same time, we're getting tons of emails from people who believe that we're keeping something from them by having a closed session meeting. And I want to explain something. Sometimes closed sessions are about personnel. We absolutely have to keep that to ourselves. We do not speak about that publicly. But any time we're in a closed session meeting, we are not supposed to come out of there and talk about what has happened within those meetings, other than maybe generally speaking. But specifics about what happens in those meetings, we keep our mouths closed about because, by law we're supposed to. We're not having closed session meetings because we're trying to keep anything from the public. We do so because legalities, sometimes you're in litigation and you have to keep things quiet until things have been ruled on. But I just needed to get that off my chest because I feel like, when the public thinks one thing, they have a perception that we're trying to somehow do things privately and not publicly. This particular resolution that was read really doesn't say anything except that we need to follow the law. That's basically what it says. And so because of that and because of the timeline, and I realize that we have been in closed session discussing ramifications of what this might do to our elections and our process. We weren't at liberty to discuss it publicly all the time. But because of that, I would like to move right now that we accept this resolution. And I hope I have a second on the board.
Excuse me, Mrs. Riggs is a second. Okay, so it's on the floor for formal discussion. Mrs. Hughes?
So I do believe that a lot of what we have discussed about this in closed session was not closed session material. Some of it was and some of it wasn't. And as you read us into close, it does say that simply because an attorney is present does not make it closed session material. This is also hugely problematic in that, you're claiming transparency, but this is not even what we were supposed to be doing tonight. We were supposed to initially be doing the superintendent's estimate of needs. Then when we discussed putting this out there, all of a sudden this resolution was added. Now, various board members have asked for resolutions to be added, and they have come up and, I have sent an email saying I'm adding this, but this was something that Cammie drafted that Ms. Anderson asked her to draft. It was not that Ms. Anderson is presenting this. As far as anybody who has spoken to legislators, I've spoken with Delegate Davis too, in my own capacity. What I have not done was write something, send it to him, and say it was on behalf of the board. Because unless the whole board has had an opportunity to look at it, it's not on behalf of the board. It's on behalf of whoever drafted it and approved it. And that's the problem here. The public's perception is absolutely accurate. We vote on things and we say we're not going to. We claim we want public input, and then we do an end run around that by voting on things at a special meeting where we don't allow the public to speak. Much of our conversation that was in closed session should have been public, and we have people drafting things and sending them to delegates on behalf of people who have never even seen them. All of those are problems. I'm not going to, I'm going to abstain from this tonight because I think it's inappropriate for us to vote on this tonight. I believe that everyone who actually works for the public and wants public input will be willing to vote on it next week.
Who else? Next.
Hughes and Weems.
Mrs. Weems.
Yeah, I mean, we've heard in closed session and tonight that there is a lot of differing opinions. There is a lot of political interpretation. There's a lot of different legal interpretations. It is not the public's fault that we've decided to wait till time has run out to bring this to the public. It is not their fault. We have talked about this for months, and I'm not saying we've tried to hide things in closed session, but we could have brought it to the public before tonight. Last week, we decided we were going to bring it forward for the public to listen to and then vote on it next week. And then all of a sudden, within 5 or 6 days, it got to where we have to vote on it tonight or we're going to hold up school board elections and we're not going to have an election in 2022. That's false. If we were scared we were holding up elections, it should have been brought before the board before tonight. Us not voting on this will not cause us not to have elections in 2022 in November. So, if we vote on this tonight, after we have said repeatedly last week, we're not going to vote on anything, after we have repeatedly said the public can't, you matter, you may as well look into the camera and say, I don't want your input, and community, you don't matter. I don't want to hear from you. You have nothing important to say about this because I'm a school board member and I know it all. So I'm going to vote on this tonight. And I don't want your input, I don't care, and that's the way I'm going to do business. This is wrong. It does not have to be voted on tonight, and y'all know it.
So let me just clarify. Mrs. Linetti started out this entire process with the timeline. And that timeline included us getting the information on the 23rd of December, 2 days before Christmas, and the first time this came up to us in a legal way was at our first January meeting. This is brand new to us. Just because we talked about it, we have been talking about it for months, but our hands were tied for months. We talked about it in theory for months. And each time Cammie stood at that podium and said, I have no idea, I have no idea. If this happens, if this happens, if that happens, this could happen and that could happen. And we were in the world of theory for months. December 23rd was the ruling. We heard about it at the first January meeting. And here we are at the end. And I don't think that this is pushing the public out of anything. All this is doing is explaining to city council in the most, the General Assembly in the most benign way that we're going to mirror city council, which is the law. This probably won't do anything. It won't do anything except we're doing this because we have a school board member that worked on legislation, language for an amendment to the original placeholder.
Who was that board member? Tell me.
I'm-
Who is that board
I'm
member?
speaking, and I'm not supposed to address each board member. We have.
You're making a
we
false
have-
accusation, or you're pointing that at
Excuse me.
perhaps.
Sounds like we have people out of order.
We have someone who worked with a delegate to change some language. It's in its third draft, and all we want to do is tell City Council, General Assembly, that this benign piece, our hands are tied by the law too. So this is not keeping the public out of anything. And for anyone to say so, go back and watch film from the past 2 years and listen to the thousands of people that have come before this board that we listen to every week. There are people here tonight. You can't get this time back. I've been here since 3 o'clock. You can't speak tonight for a special meeting, but every other night we're here till 10, 11, 12, 2 o'clock in the morning, and we listen to all of you. And so that's terrible to say that we're not listening to the public when we do. But I've made it perfectly clear that we have 9 days left before crossover. They don't work on weekends. And our only hope is that this simple resolution, as benign as it is, it's pretty much the same language from the placeholder bill that we put in that was dropped before session. That's all it says. And it's important. It's important. It's the only voice we have right now collectively that can make it up there in time.
Anybody else? Mrs. Anderson?
I realize that there are some public here tonight. But I would love for any of you to stand up and tell me that you're going to tell me, you're going to stand at that podium. I'd like you to raise your hand now and tell me.
No,
that
Mrs.
you're gonna-
Anderson, no, we're not
All right, I
inviting
take that back.
participation.
I would like you just to let me know if you'd like me to break the law. Because this resolution basically says that we are going to follow the law. That's all we're asking. Because the law is already written. The law is already written that we are supposed to have the same number of board members as there are council members. We're supposed to be able to have elections mirroring the same as city council. What are you going to tell me that's different? Are you going to tell me that you want us that you want members to come, the public to come here and tell us to break the law? Because I don't think the public wants us to break the law. They don't want that. They want us to follow the law. And so the only thing we can do right now is to basically state that we're going to follow what the law states. That's what this is about. We're not trying to do anything different than what the law already allows for. We're not trying to pull anything over on the public. Because if we were, we would be changing the law or we would be breaking the law. We're not doing that. This is not breaking the law. This is following the law. And so I don't see why if we pass this resolution, it's going to go against what our public wants us to do. As far as I know, our public wants us to follow the law and the statutes that are already written. And that, excuse me, I'm speaking. You know, it's okay for some members to contact their legislators and ask them to write a legislation that might be different than the law. It's okay for that. But it's not okay for us to pass a resolution right now that basically states that we as a school board believe that we want to follow the law. And basically that means having elections the same as city council, having the same number of people on the school board as city council. And so that's what this is allowing us to do. And it's a timely manner that we're doing it in because we need to get it to Richmond so that our delegate who happens to be writing legislation on our behalf has an idea what this board wants collectively, not what an individual wants, but what we want collectively. And that's powerful to know what the majority of this board wants. And I realize there will be some who vote against it or who refuse to vote on it tonight. I realize that. But our message to our delegate in Richmond will be that the majority of this board speaks for the collective whole of the board. And that's what message he will get. We vote on this and pass it. Thank you.
Mrs. Hughes.
So none of what the last two speakers have said have made a lot of sense to me. I don't think that if we don't have this resolution, that means we don't want to follow the law. Yes, I absolutely think that board members should be able to reach out to their delegates and senators. In fact, I think every citizen should. I do think it's inappropriate to claim that you speak for anyone other than yourself when you do, because that would be dishonest. But if this resolution is just to follow the law, I mean, we would do nothing but pass resolutions. So I don't every day sign something saying, I'm going to go the speed limit. I'm not going to smoke in public buildings, things like that. You can follow the law without having a resolution. The big problem here is the claim that we want public input, and then we do an end run around that. I do not believe we have one single member of the public, regardless of political affiliation, whether they have political aspirations, whether they're on this side, that side, who is going to stand at the podium and tell you to break the law, or that any of them are so naive as to say, they didn't pass a resolution saying they're going to follow the law. That means they want to break the law. That doesn't make any sense whatsoever. So if you're saying this resolution is just to follow the law, or it's benign as was characterized before, doesn't matter whether you vote for it or not. You plan on following the law, and if something's benign, it's really kind of a waste of time.
Ms. Owens.
Thank you. I'm really struggling with the principle of our resolution process versus the time crunch that we're in. And I'm also struggling with understanding what level of, for lack of a better term, care Delegate Davis has for what the board thinks. There hasn't been that reach out to the board to ask for that consensus opinion prior to putting forth a piece of legislation that would greatly affect this board and obviously other localities who come into this situation at whatever point. And I know that we were talking about what would happen if we don't get this resolution, out in time, and the answer is kind of, well, Delegate Davis will go on with whatever he sees fit, which is what is happening right now. I struggle with what weight this resolution will have. But I do think it's important for the board to have a collective consensus of having our voice heard. For the others who are going to vote on it outside of Delegate Davis. I really do regret that this discussion couldn't have happened sooner. I do think, I don't know how much sooner it could have happened with the final judge's order coming out in late December. Obviously, we had the two meetings in January, and if we could have gone back and done this differently, I regret that myself or some other board member who was concerned about having this conversation in this public setting didn't bring it forward, because we all know how to bring something forward on the agenda. You propose it, you get two other people to back it, and we do that. Or you have a special meeting. Everybody knows how to do it. We've done it before for other issues that we felt were important enough to do so. And so that regret I shoulder on myself, as should anybody else who's unhappy with where we are at timing-wise. I'm interested in my colleagues' thoughts on kind of a compromise. And I think that the resolution, I agree with the resolution. I think that's what, it represents my opinion, it represents where I think we need to go. I also, on principle, believe that when we have a process, we should try and follow it. Our process is, when we're doing a resolution, we have it on information, and then we are able to get public comment on either that day or a different day, and then we vote on it. Time is of the essence, but there's nothing stopping us from having a special meeting on Friday, which gives us the 3-day notice, allowing for public opinion to happen there. It still allows us to get a resolution out this week. And, it's not as fast as today. It's still 3 days later than today, but it still would allow for public opinion. I know it is a hassle and a big ask for people to come out another day, for admin to do all the things that go with making another meeting. But I kind of see that as a meeting in between to get this important resolution and having our voice heard, and still allowing for the public to be a part of resolutions that we pass. While I do think that this resolution is a little different than other resolutions that we pass, where we are passing a resolution that has a direct impact on a policy or something that is going to happen in our city for our constituents. We're not passing a resolution on something that's going to happen. This is an opinion resolution. But despite that, I do tend to have my opinion influenced at some level by the opinions of the public. And so to give an opportunity to hear the opinions of the public, I'm kind of putting that out as a not so happy, but medium for thoughts. That's what I have.
We have Mrs. Holtz and Mrs. Weems right now. Oh, you didn't want, okay. Mrs. Weems, Mrs. Weems? Oh,
Yes, you're first. You have not spoken yet.
Okay, thank you very much. I've been listening a lot and not having said a lot because so many of my colleagues have already expressed how I feel. So I'm going to throw my 2 cents in here. And thank you, Mrs. Owens, for bringing that fact up, that people are making legislation now that concerns us. And they've never asked us. We should have gotten a letter, or they should have come before the board, and they're making decisions about us. This is our chance to say, and to have some kind of input. We've never had that. And I want to thank Mrs. Felton for reading the comment from the federal judge, because all of this conversation, he's kind of gotten a back seat. And this is where we are right now. We don't have many choices. 2 things. It's a federal law that we have to follow, and then the city council, we have to mirror that. That's what we're doing. Our hands are bound as far as that goes. It's not a free-for-all. There's not a lot of wiggle room here. So this is a chance for us to, at least let them to know we have discussed it, and this is where we stand on this issue. I approve of the resolution, and I think we should vote on it tonight. At least it'll be something coming from the school board to at least let the public know something, because they haven't even, it is true they haven't seen this resolution, but we didn't know where we were going anyhow. So we need to vote on this, and I definitely approve of it. And I mentioned a few people, but I left Miss Mellick out. She said there's a lot of moving parts to this, and there are. But when you look at it, when we see it on the screen, it really is very, very simple. It is. It's been worked out for us. In 2 years, it takes an adjustment, but it'll smooth itself out. And I think everybody will be happy with the income, from what happens in the next 2 years. But when you make a big change like that, changes take a little time. So I'm happy to be able to vote on the resolution tonight. Waiting is not going to make any difference. Thank you.
Mrs. Weems?
Yes, Ms. Owens, I thought of that same thing about, having a special meeting. And believe me, if I would have thought, I never thought in a million years, last Tuesday, when we said, we're going to talk about it in public, then even Dr. Spence said, well, no, it wouldn't do any good for the public to comment because they don't know what we're talking about. Then they can come the next week, and we all agreed. If I would have thought in a million years that we were going to go back on that, I would have called for a special meeting for last week. If after Tuesday night, when I left here, I thought for sure that I knew the game plan, because we did have a game plan, and we completely have gone back on that, I would have definitely called an extra meeting. If I would have known that all of a sudden tonight was the drop dead date and that we were going to backtrack and do exactly opposite of what we said, I would have called an extra meeting. I'm fine with doing that compromise. Unfortunately, I'm going to be out of town, but I might on the road be able to zoom in. I don't know if our other colleagues would be available Friday. But again, just anything to be able to let the public know that we do want their input, since this is the first time they've seen it. Did you want to make the motion? Yeah.
Well, and may I say, when we proceed with other meetings, there's a lot of other parts that need to be consulted, staff availability, VBTV availability, so that's a tough thing to commit to be able to resolve right now. Mrs. Anderson?
I want to say that I too am open to a special meeting just to vote on this and to hear from some of the public about it. It would give the public a chance to send us emails, etc. I'm open to that, I would like to go ahead and vote on it tonight, but I'm also open to a special meeting if that's what it takes, because I do believe that it'd be worth it. But as Mrs. Rye just pointed out, we have to make sure that VBTV is available. I'm not sure how that works, but
My point being, we can't commit to that tonight, so that makes that a tricky proposition. I'm not making it up. Sometimes it takes half a day, even from home, to work all that out before committing to a date and time for a special meeting. Mrs. Manning?
Yeah, I appreciate the suggestion for compromise. I also will not be around on Friday evening, but if it gives the public an opportunity to come and speak, although I don't know how many people want to come to a school board meeting on a Friday night. But I've been told in the past that we can't have public speakers at special meetings. So we could have had speakers tonight. I don't know why we didn't.
Mrs. Linetti, do you have anything final to add to this conversation?
You could call a special meeting and add terms to it. It's not normally what you do, or, public hearings you've done. It's been a very long time since I've seen that done. But if you had a special meeting that you wanted to have it just for the purpose of getting public comment, you would have to write it in like that. It's not normally part of your special meeting procedures. But if you wanted to have a public hearing on comments on this particular issue, you can write it that way and put it in.
Well, the motion right now on the floor is concerning this resolution, just a reminder to people. Mrs. Melnick?
What if we called a special meeting and we heard the public and the public said, we agree with you, this is pretty good, send that forward, and then it's too late? And that's my fear at this whole thing. I mean, this isn't outlining anything other than the law. And I ask that we vote.
Are you proposing yours as a substitute resolution, or or a suggestion
It
that
was
you
a
waited,
suggestion.
you were waiting feedback on?
Right, I was looking for the feedback. It does seem, which I understand, the VBTV situation, that it's a big deal to schedule our meetings. I know we already had colleagues say Friday was not going to work for them, though they agree with the concept. And so at this point, I think we're probably just ready to vote.
Right, anybody else? All right, so what's up for a vote is the resolution on the screen. We've had a motion and a second. And Mrs. Linetti, if you could just add one more piece of information for us on who this resolution would be shared with.
It's whoever you would direct me to send it to, or it wouldn't be me, it would be a
So,
legislative consultant, but it would be available to anybody who wants to know what your opinion is, and if you want it directed to.
So we can have through Mrs. Felton and the legislative committee and/or you to be sure that this gets into the proper, and Mr. Andrus, that this gets into the proper hands in the General Assembly.
Correct, and it would remain in the meeting minutes, it would be an official thing for people to look at, but if you direct who you want it to get sent to, and we'll make sure it gets there.
Any other follow-up questions for Mrs. Linetti? All right, then, all in favor of the proposed resolution, kindly show a raised hand.
We have 7 ayes.
And all opposed, kindly show a raised hand. And all abstentions. And please share your reasons for the abstentions. So we'll start with Mrs. Franklin.
I do agree with the resolution. I just wish that we could take the vote on it on Tuesday. That's all.
As per our own policy, we get input before we vote, and we are not doing it in this case.
I don't have enough information to make a decision because we haven't heard from the public on this topic.
I believe it's inappropriate to vote on a resolution without public input.
So, Madam Chair, it did pass with 7 ayes, and there are 4 abstentions, so the resolution as presented has passed.
Thank you all for your time tonight. Safe drive home, and this meeting is adjourned.
Oh,